I hope you're well.
I'm doing good.
It's nice to have you on the line once again. Subsequent to the conversations we had, so two processes that are currently before court. There's one filed by Dr. Kisela Toforsen on his behalf by his lawyers. There's another one filed by Mr. Richard Jakpa. They are both seeking virtually the same thing, that the charges against them be struck out. Have you seen these processes, and what are your own thoughts?
Okay. We have various processes which can be brought before our various courts. Now, what they have put before the court is that there have been some happening, and they do not think that the said happening will give them any comfort or will not ensure that they get a fair trial. And for that matter, they think that the court should declare the said process as a mistrial, or that you have to see the said case. I wouldn't want to discuss the merits of this instance matter because it is before the court. I'm out of the court, and so I'm always acting right. I would want to deal with the issue of the mistrial. Of course, my learned court did make the intimation that even when we do not have a particular system in the country, we could, through such cases, find a way to introduce that it will bode well for our justice system. And I'm happy to say that the determination of this particular matter will serve as a precedent to other matters which will come up. But let me make this point clear. When court takes the matter, it does not mean that the matter is ended. It means that at a point in time, the case can be taken up again. Two, when a court even declares the present trial as a mistrial, to the extent that the application was made by the accused person, it means that Attorney General can come back to court again. Now, there are various situations where we can have a mistrial coming up. Some could be that the court, probably the cause of it, will say that it doesn't have jurisdiction over the matter. And of course, the judge will go to the extent of declaring a mistrial. It could also be that there has been some proven misconduct, some proven prosecutorial misconduct, which will not, as it were, inure to the benefit of the accused person. And for that matter, a mistrial can be led. It can also be that the jurors who are handling the matter, probably one of them might have passed on, and for that matter, they cannot continue with the trial. That can also come up with a mistrial. You can also have a situation where the jurors don't agree in respect of finding the accused person guilty or not guilty, what we call the hung jury. In that case, the court can also declare a mistrial. But as I indicate, a mistrial doesn't mean acquittal. So the present application where the first and third accused persons are asked the court to declare a trial, the court can grant it, but it does not stop the Attorney General from bringing back the matter because they have not either been convicted or, as it were, freed by the court. It is only when they have been convicted or freed by the court that any attempt at a trial will be seen as a noble jeopardy to the accused person. So, yes, in the present circumstances, if what is being said as having been done by the Attorney General is true, then one could talk about editorial misconduct on his part, that he wants the evidence to be filtered in a particular way in order to gain a conviction of the first accused person. That would be one of the reasons for which we can even declare a mistrial. Now, when that mistrial is declared, as I said earlier on, you will have, the prosecution can have the option. There can be three options on the part of the prosecution. When a mistrial is declared, the prosecution can decide that, okay, fine, we are no longer going to worry our head for this particular case again. Or it can enter into a plea bargain negotiation, to have the matter settled. Or it will call for a retrial. So there are three options left to the Attorney General, even where the mistrial which the accused persons are applying is in place.
But that will have to happen if the court declares a mistrial. Now, I also want to what's the difference between striking out the charges against someone and a mistrial that Dr. Kisela Toforson is asking for? Because Mr. Richard Jakpa is asking for the charges to be struck out against him. What's the difference in what they're asking for?
Okay. So in case of the charges being struck out, in that case, the court will have struck out the charge against the person. And so, in respect of that particular charge, it cannot be brought against that person in where the court strikes it out. It is as if it exists. But when you ask for the stay of the trial, it means that you want whatever is happening currently at the court to be put in abeyance, that they should stop it, to await a certain action that is going to be undertaken. But as I speak to you now, I don't know what next action the accused persons are going to take, and for which reason they are asking the court to stay proceedings. What they can ask for, which I may agree with, is the issue of the mistrial, because they are of the view that there are certain developments which they think will not make any judgment or any verdict given in respect of that matter to be justifiable or to be anchored in true justice. And as I did say, a case in point is what is being referred to as the conversation between Jakpa and Attorney General. If you listen to the third case, it is not the best thing for an AG to do. And I'm saying this with a caveat. If it is indeed true that the voices that we heard are voices which belong to Attorney General and Jakpa, and that the statements that were made were indeed made by the Attorney General.
In fact, if you read the Daily Guide of yesterday, they make a quote from the Attorney General's response to Mr. Jakpa, where he says, the quote is, the application anchored on untruth and a skillful manipulation of facts seeks to clothe the applicant with immunity from prosecution, and to this extent is incompetent and offensive to Ghanaian law. The opening alone, the application anchored on untruth and a skillful manipulation of facts, does it suggest that Attorney General intends to perhaps present evidence to show that what is being accused of is untrue? Is that the indication? Does it give you that indication?
Of course, the court can hear the matter. Lawyers will have to do some few presentations or comments based on what has been disposed of in the application. There could also be the situation where the lawyers will ask that evidence be taken in respect of the But of course, one should not be surprised at the response of the Attorney General. You wouldn't expect the Attorney General to come and say that what has been said is true for. I watched one of these network television, and I saw the representative or the spokesperson of the Attorney General making some comments. I was hugely disappointed. I saw the attempt to just defend and defend and defend without even considering that there are that also have done and done well. And it was more like praises on assessing a superhuman quality of finesse that the Attorney General has. Somebody has said the Attorney General is not qualified to be there. It's like Godfred Dame is a very fine lawyer, very knowledgeable, very smart. What is an issue is what he's alleged to have done. So even if he was working at midnight at the General Department to show the extent of hard work he has been undertaking as an Attorney General, the issue before us, and when I say I'm talking about Ghanaians, the issue that has knowledge is what is alleged to have done. Did he do it or did he not? And what was behind it? It appears most of the explanations that we have from Attorney General, they are like a sign. The more they talk, the more they rather take the Attorney General into the mass. So one would have expected them to have rather kept quiet, or even where they were going to respond to the affidavit, they will have to be a little bit careful not to use words that may not be finding that, and coming from the law office. So I don't think that there has been any instance where these accused persons have said that they are above the law, or they have said that they don't want to stand trial. That's not what they have said. They have been always ready. They have been coming to court. There have been the attempt to even plea bargain under Section 35 of the Court Act, which I'm told that Attorney General wasn't happy with, and for that matter, did not agree. So if he did not agree to the people paying the money, because what is the issue is that these people have more or less misappropriated, of course, the loss to the state, a whooping amount of 2.3 million euros. We have people who are coming and they are asking for and on behalf of the accused person, saying that we are coming to pay back that money which is supposed to have been lost. We are ready to pay, including interest. And then the information is that the AG department is saying no. So what is it? So what all these issues that give currency to the fact that there are other motives beyond these accused being put before court. And it is compounded where you have an accused person pleading. You have an accused general pleading with the accused person that, look, slow down your evidence. Wait for me. I'm going to travel. When I come back, then you can continue. And then when it was said that that may not be possible, then the suggestion is made that, then why don't you go in for a medical report? I don't think, as I did say, if this is what really transpired between Japa and Attorney General, there is no way any person with a good head on his shoulder can defend this act. It is reprehensible, and in any civilized society, the Attorney General would have even bowed that long time.
In fact, he is not the only one who has defended it. I'm sure you've heard lawyer Frank Davis on many platforms.
Frank Davis is not talking with the heart of a lawyer. He is talking as a politician, and I don't want to go there. Those persons will be doing their own politics. Just like the NDC is doing his own politics of this particular happening. And the truth of the matter is that if it were to be the shoe on the other leg, if it had been the NDC in power and this thing has happened, the vehemence with which the NDC is pushing this issue would have been the same vehemence that the NDC will have also pushed the issue. And so, for me, I don't want us to stray into the statement or effusions of the political party as well press conferences and whatnot. I will want to see persons put on their real cap as lawyers, speak honestly to the issue, and say that this is not good enough for our justice system, where an attorney general is head more or less goading an accused person to ensure that he plants evidence to get the conviction of another accused. No, this is scandalous. This is terribly injurious and should not be condoned at all. The attorney general can be my friend, he can be my brother, he can be anything. And wrong is wrong. And we should be bold enough to tell people that what has happened or what is being done does not help. Look, what has happened can happen to just anybody. And what it also means is that it's not tell people that now in Ghana, when you even get a case, the possibility is that there can be certain things happening possibly on your blind side, which will push you into jail without you even knowing. I think that our justice system must be seen to be honest. It should show the altruism, the fact that people appear before the court. If they are good, they are found as such. If they are not good, they are declared as such. So that at least everyone who appears before a court can be assured. But we have had situations where even security, Minister of Security, is even advising that, this particular court, your verdicts are becoming too predictable. So we beg you should be very careful. Don't be seen to be always showing unanimity in your judgment or your ruling. Why should somebody say that? If that is what it takes to be the case, let it be. If there is unanimity, if thousands and one applications are put before a court, and the court is of the honest that particular application has no merit, it must dismiss it. There should not be a situation where somebody will advise judges that please don't always be coming up with unanimous decisions. They are not helping. They are creating any tension, or they are bringing about any security challenges. So when we are now having an attorney general meeting an accused person in the house of a Supreme Court judge, folks, this is a very serious matter. And we lawyers, look, we have our hands back, especially so when our leader is in the midst of this.
And I'll thank you very much for speaking to us this morning. Just for the sake of emphasis, you and Lawyer David Ametepe agree on one thing, that this decision, whatever decision the court comes to, will be precedent that will guide future action.
One thing I'm happy is that just before this particular meeting is coming, I don't know if she be a very hard work. She does a lot of researches. You read her opinion, and one cannot but admire. So let's see what comes out of it.
Always a pleasure talking to you. Thank you very much for speaking to us.